SMN Station Mission Education. SMN Station Mission Education. SMN Station Mission Education.
Good morning, students. I am Prakash Raj Pandey, present in this video to discuss the subject matter relating to law of contract, which include meaning, nature, and essentials of valid contract, meaning of offers, rules regarding offers, meaning of acceptance, rules regarding acceptance, seize or revocation of an offer, and seize or revocation of an acceptance, and at last, communication of offer and acceptance. Okay. However, I am discussing the subject matters right here. At the same time, I am also wishing you, the student, starting to subscribe, share, like, and comment on the video. Please keep watching. Thanking you. Now I am going to discuss right here that the title is Law of Contract. Now let's see what does it mean. I mean, an agreement enforceable by law is simply called the contract. According to the Nepalese Muluki Civil Code, a contract is any agreement between two or more persons to do or not to do something which can be enforceable by laws. It is also said that contract is the basis of all types of business activities, since all the activities like employment, sales, purchase, credit creation, transportations, and so on are directed by the agreement between the parties. That's why the study of law of contract precedes the study of all other subdivisions of business law. It is also known as the private legislation, which is performed between two or more than two parties. According to the Oxford Dictionary, the meaning of contract is an agreement, the object of which is enforceable by law. Similarly, according to Allsbury, a contract is an agreement made between two or more persons which is intended to be enforceable at law. Okay, now let me analyze definitions regarding the contract. The definition given by different writers are vague and various. Among them, some prominent authors of law like Salmond, David Walker, and Henry Campbell have given the definitions of contract in favor of obligations. Likewise, some authors like Anson, John B. Saunders, S. States, and Donald T. Clark, and so on, opine the definitions of contract in favor of consideration and competent parties. As for example, let me have to quote some samples like, according to Salmond, a contract is an agreement creating and defining obligation between the parties. According to John B. Saunders, S. States, a contract is an agreement between competent persons upon a consideration to do or to abstain from doing some act. In addition to this, according to Anson, a contract is an agreement enforceable by law made between two or more persons by which rights are acquired by one or more to acts or forbearance, self-control on the parts of others. From the above mentioned definitions, we may come to conclusion that the contract includes the following key points. Number one, to be the valid contract, there must be at least two or more than two parties. Number two, any agreement to do or not to do or to abstain from doing some act must be on the ground of free consent. Number three, exchange of promise by meeting of mind between parties, that is consensus ad idem, is necessary to the valid contract. Number four, enforceability of the liabilities by law is another key point, which means a valid contract have capacity to enforce liability of the party through the competent court of law. Number five, in a valid contract, rights and liabilities that are credited reciprocally between the concerned parties. Okay, that's all. Now, let's see the title, that is nature of contract. As regards to clear the nature of contracts, the following points can be discussed. Number one, the nature of contract is an agreement. It means an agreement comes into existence only when one party that gives his or her acceptance thereto. Thus, there should be plurality of persons because one person cannot enter into an agreement. So, an agreement includes consensus ad idem. It means both the parties to an agreement in the same sense at the same time to become the contract. Number two, the nature of contract is a legal obligation. It is another nature of contract. An agreement to be a contract must give rise to a legal obligation, that is the duty enforceable by law. If an agreement is incapable of creating a duty enforceable by law, it is not a contract. It is said that all contracts are agreement, but all agreements are not contract. It will be appropriate to point out here that the law of contract deals only such legal obligation which emerges from agreement. Number three, the nature of contract is creation of legal rights. Okay, what does it mean? Regarding to discuss the legal right, law of contract creates jus in personam as distinguished from jus in rem. Jus in personam means a right against or in respect of a specific person. It is available only against a particular person. As for example, to complete the contract regarding to do or not to do any subject on the ground of free consent between competent party is like the right of personam of one another is that particular agreement. On the other way, just in way means a right against or in respect of a specific thing. It is available against or at large. Thus, law of contract clearly provides remedial rights of aggrieved party against others. That's all. Okay, right now I am going to discuss here on the essential element of valid contract. The essential elements of valid contract are as follows. Number one, offer and acceptance. Number two, legal relationship. Number three, competent parties. Number four, free consent. Number five, lawful objectives. Number six, consideration. Number seven, not expressly declared void. Number eight, possibility of performance. Number nine, certainty. Number 10, verbal, written, and registration. Okay, now let me have a little bit details on each and every points. What they provide the insights to us, it will be clear to understand essential element of valid contract that could be meaningful for us too. Then okay, let's see how can we describe them one by one. Firstly, offer and acceptance. There must be lawful offer and lawful acceptance of the offer, thus resulting in an agreement. Secondly, legal relationship. There must be an attention between the parties. That agreement should be attached by legal consequences and create legal obligation. Okay, let me give an example. Mr. A promises his wife, Mrs. B, to get her a sari if she will sing a beautiful song. Mrs. B sang the song, but Mr. A did not bring the sari for her. In this case, Mrs. B cannot bring an action in a court to enforce the agreement as it lacks the intention to create legal relation. So, legal relation is important to be a valid contract. Okay, next. Thirdly, competent party. The parties to an agreement must be competent to contract, otherwise it cannot be enforced by court of law. If any of the parties to an agreement suffers from the minority, lunacy, fraudulent, and insolvent, and so on, the agreement is not enforceable. Hence, the contract made with any one of them is generally void. Fourthly, free consent. It is another essentiality of the valid contract. Consent means that the parties must have agreed upon the same thing in the same sense. If the agreement is induced by coercion, undue influence, fraud, misrepresentation, or mistake, the contract would be voidable. Fifthly, lawful objectives. The objectives must be lawful. If the objective is unlawful, illegal, immoral, and opposed to the public policy, it cannot be enforced by the law of court. They are void from the beginning of the contract. Sixthly, consideration. What it means? Consideration has been defined as the price paid by one party from the promise of another. An agreement is legally enforceable only when each of the party gives something and gets something. Consideration must be real and lawful, which may be in past, present, and future. Seventhly, not expressly declared void. The agreement must not be expressly declared void by statute or by any government orders. Eighthly, possibility of performance. The objectives or terms of the contract must be possible to perform. Impossible contract is not valid because performance is the very nature of contract. Any act which should not be done or is non-performable does not create legal obligation to the contracting parties. Ninthly, certainty. Precision, certainty in object, terms, and conditions of contract is another element of valid contract. Agreement must be certain and not vague or indefinite or words of latent ambiguity. Let's see an example related with A, B, and C. I mean, like A asks B to get married with C, and A promises to pay some money to B if she gets married to C. Is it valid? No. This agreement is not valid. And lastly, verbal, written, and registration. A contract may be verbal or written form. As for example, for the sales and purchase of immovable properties, contract must be made in written form and should also be registered in concerned department of the government in our country. Thank you. That's all. Anyway, please feel free and make emails of answering of these following questions. They are: what is contract? Explain the essentiality of valid contract. Or all contracts are agreement, but all agreements are not contract. Justify this statement. Now I am going to discuss right here that the title is Rules Regarding Offer and Acceptance. Offer and acceptance are the first essential element of valid contract. I mean, there must be lawful offer by one party and a lawful acceptance of the offer by another party. The rules of offer and acceptance can be discussed from the following perspectives. Let's see an example. Mr. A offered to sell motorbike to Mr. B for rupees 3 lakhs and 50,000, and Mr. B immediately accepted The offer. Mr. Yates' contract comes into being provided other essentials of the valid contract like that of competency of parties to contract, etc. are present. It is said that offer means proposal put by a person with a hope to get assent from other to do or not to do something. Thus, the proposal includes the following essentials. Number one, it must be an expression of the willingness to do or abstain from doing something. Number two, the expressions of willingness to do or not to do or to abstain from doing something must be to another person. It can be known as a proposal by a person to himself. Number three, the expression of willingness to do or abstain from doing something must be made with a view to obtain the assent of other person to such act or abstinence. As for example, if A asked to be at first, do you intend to sell your car? It is just inquiry, but it is not the proposal. At second, I sell my car if I can get rupees 5 lakhs for it. It is also a statement of intention, but not the proposal. At last, will you buy my car for rupees 5 lakhs? Or I am willing to sell my car to you for rupees 5 lakhs. It is the proposal which has made the object of obtaining the assent of B. Thus, the person making the proposal or offer is called the promisor or offerer. The person to whom the offer is made called the offeree, and the person accepting the offer is called the promise acceptors. Did you understand? Okay, thank you. Thanks a lot. Right now, please attention here on the rules regarding offer only. A valid offer must be in conformity with the following rules. Rule number one, an offer may be expressed or implied. Rule number two, the offer must intend to create legal relation. Rule number three, offer must be certain and should be made to a definite person. Rule number four, offer must be communicated. Rule number five, invitation to offer is not offer. Rule number six, offer must be conditional. Rule number seven, offer is seeking the acceptance of other parties. Okay, now let me have little bit details each and every point what they provide. Firstly, an offer may be expressed or implied. An offer can be made either by words or conduct. An offer which is expressed by words, spoken or written is called an expressed offer. And one which is referred from the conduct of a person or the circumstances of the case is called an implied offer. Secondly, the offer must intend to create legal relation. A social matter like an invitation to play cards does not create legal rights and duties between the parties because there is no intention to create legal relation. Thirdly, offer must be certain and should be made to definite persons. To form the valid contract, there must be clear and certain terms. If the offer is latent ambiguity, it creates confusion and cannot be enforced in the same sense and same time. As for example, Mr. X says, Mr. Y, I will sell my car, or will you buy a car, or do you want to sell your car? There is mere statement of intention, which does not create certainty. Hence, it will not be the offer for valid contract. Fourthly, offer must be communicated. When there is no communication of offer to the offeree, there is no acceptance, resulting in the contract without the knowledge of an offer. How can an offer accept it? Fifthly, invitation to offer is not offer. Invitation to offer is only a statement which differ from a valid offer since there is no intention of the offerer to obtain assent from the offeree. As for example, intention to sell and quotation of price and so on are not offer. Sixthly, offer must be conditional. It may be made on the subject to condition and that must be clearly conveyed to the offeree. Illegal offer must not be included to make it conditional. Seventhly, offer is seeking the acceptance of other parties. An offer is created to seek acceptance of other parties which is made to whom an offer is not valid if there is made to the general public or the world at large. Again, let's see the another title, that is seize or revocation of an offer. Offerer make an offer to do or not to do or to abstain from doing some act can revoke it at any time whenever he likes. It depends on his will. It is to be remembered that before creating contractual liability, an offer can be lapsed or terminated in the following conditions. Condition number one, by notice of revocation. Condition number two, by the death or insanity of either party. Condition number three, by expiry of time. Condition number four, not fulfillment of any conditions. Condition number five, by the rejection of the offer by offeree. Condition number six, by subsequent illegality or impossibility. Condition number seven, by destruction of subject matter. Okay, now let me have a little bit details. Each and every point what they provide the insight to us. Number one, by notice of revocation. The offerer may at any time withdraw the offer by sending a notice of revocation to the offeree. Before the notice of acceptance is received by the offerer, notice of the revoked offer must have come to the knowledge of the offeree through any means of communication. Number two, by the death or insanity of either party. According to English law, death or insanity of either party before making acceptance causes an offer to lapse, although the party has no notice of death or insanity. As for example, if we imagine an offer between Mr. A and Mr. B, that in case if Mr. A dies, the offer will be terminated. Similarly, if Mr. B dies, offer will also be terminated. In this case, although both the parties, either Mr. A or Mr. B, has no notice of either Mr. A's or Mr. B's death or insanity. Number three, by expiry of time, an offer must be accepted by the offeree within the stipulated time in the offer, if any. Otherwise, the offer is automatically terminated after the expiry of such stipulated time. If no time is prescribed in the offer to accept it, the offeree has to accept it within a reasonable time. By expiry of such time, the offer is automatically terminated. When we talk about reasonable time, it may be long in some cases as well as short in some cases. It may vary case to case. Number four, not fulfillment of the condition. If there is condition in the offer and such condition must be fulfilled at first, but if the offeree accepts it without fulfilling such a condition, the offer is automatically revoked. Number five, by the rejection of the offer by offeree. Rejection means a refusal to accept what is offered. Offeree can accept or reject the offer made to him. Rejection may be expressed through words of mouth or in writing or implied, that is counter offer, and so on. Rejection takes place in any of the following form, like counter offer, conditional acceptance, non-fulfillment of condition, failure of accepting modes, and so on. Failure in all of the forms result the termination of offer immediately. Number six, by subsequent illegality or impossibility. After the offer is made, but before it is accepted by the offeree, if the matters related in offer becomes subsequently illegal or impossible to accept, the offer is revoked. Number seven, by destruction of subject matter. When the subject matter of the offer is destroyed before the offer is accepted by the offeree, the offer is revoked. Okay, now I'm also going to discuss right here that the title is acceptance. What does it mean? The word acceptance is simply called an assent or consent signified to an offer. In other words, it is an act of expressing assent to the offer by the party to whom it is made is called an acceptance. It is said that acceptance is also a result of expression of assent. According to Indian Contract Act 1872, a proposal, when accepted, becomes a promise. When the person to whom the proposal is made signifies his assent, thereto the proposal is said to be accepted. According to Nepal Civil Code 2074, acceptance means the consent of the offeree over the subject matter in the same sense which is taken by the offerer. Thus, acceptance is the manifestation by the offeree of his assent to the terms of offer. Acceptance is necessary for making the valid contract. Both the offer and acceptance are equally important. Without acceptance, offer alone cannot create a valid contract. Thereby, acceptance is an assent given by a person for the proposal made by another. If a person proposes something about to do or not to do, and other person gives his assent immediately, it is called acceptance. Now, look at the title here on the rules regarding acceptance. Number one, acceptance must be given only by the person to whom the offer is made. Number two, acceptance must be absolute and unqualified or unconditional. Number three, acceptance must be communicated by the acceptor. Number four, acceptance must be after offer. Number five, acceptance must be given within the reasonable time, that is before the offer lapses or revoked. Number six, mental acceptance ineffectual. Number seven, rejected offer can be accepted only if renewed offer. Now let me have a little bit details on each and every point. What they provide insight to us, it will be clear to understand rules regarding acceptance that could be meaningful for us too. Then okay, let's see how can we describe them one by one. Number one, acceptance must be given only by the person to whom the offer is made. An offer can be accepted only by the person or persons to whom it is made, and it cannot be accepted by the another person without the consent of the offerer. As for example, if you propose to make a contract with Mr. A, then Mr. O cannot substitute himself for Mr. A without your consent. Number two, acceptance must be absolute and unqualified or unconditional. In order to be legally effected, it must be an absolute and unqualified acceptance of the terms of the offer. Even the slightest deviation from the terms of the offer makes the acceptance invalid. It happens, acceptance is regarded as counter-offer in law. As for example, Mr. A offered to Mr. B his motorcycle for rupees 80,000. B accepted the offer and changed rupees 20,000 by letter. There is no contract as the acceptance was not absolute and unqualified. Number 3. Acceptance must be communicated by acceptor. Acceptance must not only be made by the offeree to be valid, but it must also be communicated by or with the authority of the offeree to the offerer. Number 4. Acceptance must be after offer. The acceptor must have knowledge of the offer and acceptance must be given after the offer. If someone performs any act as earlier as offer, he have no right of this type because he has no knowledge of the offer. Number 5. Acceptance must be given within the reasonable time. That is before the offer lapses or revoked. It means acceptance must be given within the specified time. If any and if no time is determined, acceptance must be given within the reasonable time. Number 6. Mental acceptance ineffectual. Mental acceptance or quiet assent is not evidence. Acceptance must be communicated to offerer properly, otherwise it has no effect. Number 7. Rejected offer can be accepted only if renewed offer. It means once rejected cannot be accepted in the same sense again unless a fresh offer is made. Okay, now I nearly at the end of my lecture on revocation on lapse of acceptance. Why not we start with elaborate them one by one? Let me have little bit details each and every point what they provide insight to us. Revocation or lapse of acceptance, what does it mean? Let's see. An acceptance could be revoked. Although the offeree has accepted the offer made to him, he can withdraw his acceptance, which is called revocation of acceptance. When acceptance is revoked, there is no creation of valid contract. In any of the following ways, an acceptance is lapsed. Let's see. Way number 1. By notice. It means an acceptor may revoke or cancel the acceptance by sending a notice, but such a cancellation is not valid if the offerer has received the notice of cancellation earlier. Way number 2. By death or insanity of the acceptor. The acceptance is cancelled in case of death or insanity of the acceptor. Way number 3. By lapse of time. Acceptance lapses where the acceptance is not communicated till the prescribed time. Way number 4. By counter offer. Likewise, the acceptance is revoked when it is made with an alteration of subject matter. Way number 5. By non-fulfillment of terms. If any condition or act given in the proposal is not fulfilled, the acceptance will be revoked.
Now, let me have to discuss about communication of offer. Communication of offer refers to a process of transforming or giving notice of the offer from the offerer to the offeree. Offer must be communicated as I mentioned earlier that where there is no communication of offer to the offeree, there is no acceptance resulting in the contract. Without the knowledge of an offer, how can an offer accept it? That's why the proposed offer must raise the offeree and he must have the knowledge of such offer. Communication of offer is completed only when the offeree is informed about it. According to Nepal's Civil Code 2074, the act of sending offer is supposed to be completed when the offeree gets its knowledge. According to Section 4 of Indian Contract Act, communication of an offer is complete when it comes to the knowledge of the person to whom it is made. Unless and until communication of the offer is complete, it does not amount to contract. The offerer does not become liable or the offeree does not claim anything. Now, let's see the communication of acceptance. The communication of acceptance refers to a process of transmitting notice of sending acceptance by offeree to the offerer. As I mentioned earlier in the topic called rules regarding acceptance, that acceptance must not only be made by the offeree to be valid, but it must also be communicated by or with the authority of the offeree to the offerer. According to Muluki Civil Code 2074, that communication of acceptance has two aspects. They are number 1, as against the offerer when the offerer gets notice of acceptance sent by the offeree, and number 2, as against the offeree when acceptance comes to knowledge of the offerer. Similar provision can be found in the Indian law in the matter of communication I saw the similar case in English law too.
That's all for today. Now I would like to thank you once again for watching this video and also requesting all of you to like, subscribe, share with friends and relatives. When you are residing themselves, please switch on bell icon for more exclusive. The subscribe button and bell icon is just below. Keep watching. It will be memorable, useful and worthful. Don't forget, please subscribe, share, like and comment for latest uploads too.